Did you get the discovery from the public defender?
No, Your Honor.
Why not?
Because at that time, we have a deal that's behind.
Listening to the back and forth between the attorney and the defendant is honestly exhausting. It feels like they're just going in circles, wasting time instead of being direct. The lawyer is giving Judge Simpson the longest runaround ever, instead of clearly explaining what's happening. You can see the judge getting increasingly frustrated until he finally snaps, telling the lawyer to get it together. Honestly, it's hard to blame him. How are you supposed to negotiate a plea deal?
This case, People versus Rashad Ahmad.
Ready, Your Honor. Good afternoon, Your Honor. Hassam Al-Qudsi on behalf of the defendant.
Rashad Ahmed.
I have a plea form in front of me that indicates that the defendant is going to be pleading guilty to attempted interfering with electronic communications. That's a 1-year misdemeanor. That's a count 3. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. The defendant is also agreeing to pay full restitution, and there's a sentence agreement, although I cannot bind the sentencing judge. In this case, there's an agreement to no upfront jail. The prosecutor and defendants are agreeing to that.
That's correct.
Yes, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Rashad Ahmed.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted interfering with electronic communications. That is a misdemeanor punishable by up to 1 year incarceration, a $500 fine plus court costs. Do you understand that?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
All right. Still wish to plead guilty?
Sorry?
Do you still wish to plead guilty to this charge?
Your Honor, may I say something? Just something happened. The victim is here. Just want to let you know.
Okay.
And may I approach, Your Honor?
Yeah.
I'm sorry about that.
All right, sir, understanding the maximum penalties in this case, do you still wish to plead guilty to this charge?
Yes, sir.
And to that charge, how do you plead?
Yes, sir.
How do you plead? Guilty or not guilty?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form. Is that correct?
Yes, sir.
Do you have any question regarding those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
July 8th, 2025, at the location of 1480 Parkwood Avenue, Ypsilanti Township, Washtenaw County, State of Michigan. What did you do what did you do that makes you think that you're guilty of the offense of attempted interference?
May I form the question, Your Honor? I'm sorry. Did you text her? You put a daughter via Zelle and text her? Did you do that?
After the court, you mean?
No. The judge is asking you, did you text her? Did you text her, send a text message via Zelle?
Yeah. Yes, I did.
Without even reviewing the discovery, watching it is awkward, sometimes funny, but mostly just frustrating. Some lawyers really seem to treat courtroom chaos like part of their strategy. Let's break it down and see what happens. This defendant pleaded guilty to attempted interference. But honestly, the only person more confusing than him is his own lawyer. It's one thing when a defendant doesn't fully understand English. But when the lawyer struggles over basic words, the courtroom starts feeling like a language lesson gone wrong. Judge Simpson is trying to stay calm, but you can practically see him mentally face-palming. The law is meant to clarify, not remix itself. And here's the thing. Pleading guilty without making sure the defendant fully understands can actually invalidate the plea later. Judges repeat themselves for a reason. It's not theater. It's legal protection. But even that doesn't help here. The lawyer keeps answering questions with, and I think, which is exactly the wrong thing to hear in court.
It's like it was send money. It's not text.
Yeah, I know.
Yeah.
How does that, I don't know how I get to the charge.
That's the only electronic device that he attempted to do. He was texting her, giving her a dollar through Zelle so he can text her a message.
Sir, I'm just saying, whatever is being said to me doesn't sound like the offense.
Mr. Ahmad, on that date, were you with a Kimberly Chavaria?
مش فاهم.
He doesn't understand.
Like,
Who is this Kimberly? He's saying he doesn't understand. Kimberly?
Yeah, هي اسمها. Yeah.
She's asking you. You were with her on that date?
Yeah.
Okay.
Okay. And on that date, did she try to contact 911?
Yeah.
And did you take the phone from her?
No, I didn't take the phone because she didn't try with the phone. She did try with Alexa.
Did you tell Alexa to stop calling 911?
Because Alexa said just one time, because Alexa said she can call 111 and start talking something else. That's why I stopped Alexa, because Alexa didn't, like, how we can say.
So you stopped Alexa from calling 911?
And not for calling, no. Alexa, after she called 911 and Alexa, it doesn't work for call 911. And they start talking, like,
Did you take her phone from her at some point?
No.
All right, well, I can't accept the plea. I don't have a factual basis.
Your Honor, so we do a preliminary exam. Your Honor, right?
Okay, there will be a preliminary exam set. I will assume that all discovery is complete.
Oh, no, there was.
I will assume.
Your Honor, there was no
Can't
discovery.
accept the plea. Pardon?
There was no discovery. We didn't get any documents, police report and anything. Because at that time, we thought that we have
Well, why am I taking a plea if there's no, this doesn't even make any sense. What?
Yeah, and my file discovery is tendered. You've sent over the media as well as the 911 call has been uploaded.
I never received it, Your Honor, 100%.
Was it sent to him? He's been the only attorney on the case, so.
There was another attorney before me, Your Honor. It was a public defender.
Did you get the discovery from the public defender?
No, Your Honor.
Why not?
Because at that time, we have a deal
For
that's the client
Pete's
will.
sakes.
Your Honor, I believe we sent discovery to both the public defender. I believe Ms. Stedman was also on this case prior, and the discovery was also sent to her.
And you're saying from neither prior attorney did you get discovery?
No, Your Honor.
Can you send it to him now? Because I'm setting this for exam. I'm not playing around with this anymore. Send a discovery to them. This will be set for preliminary examination in person, September 9th, 2025, 9 a.m. That's before me. I'm going to quit playing games. Bond continues.
It's like watching a slow motion disaster where everyone is pretending it's okay. You can tell the judge is trying one last time to get clarity before it gets worse. Even the court reporter looks like she's given up on keeping a straight face. No wonder defendants lose trust in the system when representation looks like this. What's even crazier is that this attorney is willing to accept a plea deal without asking for discovery. That's basic work. A busy public defender could have given the same level of service. Why pay top dollar for subpar representation? And the worst part, the lawyer fails at his job, but still gets paid. If he had done the homework from the start, the case could be done. Instead, he bills for extra time reviewing discovery and returning to court, basically getting paid for his own mistakes. The system lets incompetence profit from confusion. Honestly, How did this lawyer even pass the bar? Did he cheat, or was the grader just feeling generous that year? I feel bad for the defendant here. It might be the rare case where the client is actually smarter than the lawyer. What do you think? Should the courts hold lawyers accountable for lazy or sloppy work?